21st of January 2019, the French Data Protection Authority, the CNIL, finally brought down its decision in relation to Google's failure to comply with the GDPR. The agency found that Google had failed on two counts. The first was a failure to comply with the GDPR requirements to provide transparent information to data subjects via its Android application, and secondly, it found that Google had no legal basis for processing personal data in respect of its personalised ad functions. The standout message, I guess, with this decision is it's the world's largest penalty for failure to comply with the GDPR. The fine was so large, I think, for a couple of reasons. The first being that the agency, the French Data Protection Authority, the CNIL, wanted to make an example of a big player very early on in the piece, and unfortunately for Google, that they were in the gun sights. The agency also made reference to the fact that the breaches of the GDPR were continuous, still occurring, and found that aggravated nature of the failure to comply justified the 50 million euros. The GDPR is a European-based legislation, and it does have extraterritorial reach, so it does reach out and impact organisations outside the European Union. For those organisations in Australia that are subject to the Privacy Act, to the extent that they also have a physical establishment in the EU, so a retail site or some other office present in the EU, the GDPR will apply to them. It will also apply to those Australian organisations that, perhaps not having a physical establishment in the EU, they do sell goods or services into that market. So they may sell goods or services online, or they track or monitor customer behaviour in the EU. So if you fall into those categories as an Australian organisation, you're likely to be required to comply with the GDPR. The impact of the Google GDPR decision for Australian companies needs to be seen in context. Obviously, the fine is a huge amount of money, but we have seen over 59,000 breaches within the EU and 91 associated fines to date. The majority of those fines are a lot less than the fine that's been imposed on Google. That said, we have also seen some enforcement action against overseas organisations, particularly one in Canada. So for an Australian organisation, I think that the message is out there for those organisations that do need to comply with the GDPR, then it needs to be very much on their radar. For those that don't, I think it's probably more a message around is this a broader trend towards greater compliance that we need to be looking at from an Australian perspective, and certainly the Australian Office of the Australian Information Commissioner, now that it's been better resourced following the recent election, they are looking to take more of an enforcement approach rather than the education-based approach they've taken today. The GDPR has been in place now for over 12 months. So if you're an Australian organisation that's required to comply with the GDPR, now's probably the best time to ensure that compliance. And the Google decision obviously is a bit of a wake-up call for those organisations that haven't got their house in order. It does provide a nice laundry list of important issues to cover off in relation to your privacy practices. Ensuring that you provide upfront and transparent information about how you're handling personal information, perhaps including an FAQ section within your website and materials to answer customer queries and issues that are important from a customer perspective, and making sure that if you do have any fine print, that it's right up there in front. Don't be burying that fine print and the T's and C's away from the customer view. Make sure that you're very open and upfront about that sort of information. Those sorts of activities where you're I guess improving the transparency of how you're handling and managing customer information will go a long way to assist you in complying with the requirements under the GDPR. The key for Australian organisations to ensure ongoing compliance with privacy laws is to view privacy as being an ongoing discussion. It's not a tick-a-box exercise. So ensuring that the privacy policy that you've drafted doesn't sit idly on a website or gathering dust on a filing cabinet, but is actively being used within the organisation. So your staff, your contractors are trained up, they're aware of their privacy obligations, and it's very much a living document that's very much part and parcel of how you do business from a privacy perspective.